Imagine you're sitting on a jury in a serious criminal trial. You're listening intently as the prosecution presents evidence that the person in the dock, the accused, committed the specific crime you're deliberating on right now. But then things get complicated. You start hearing about other things the accused is alleged to have done, maybe even other crimes they're formally charged with, perhaps right there on the same indictment, but they're separate counts.
Right.
The prosecution's argument isn't just about the evidence for this specific charge. They say, look at all these alleged acts together, the one he's charged with here, and these others, maybe even ones he's also charged with elsewhere in the trial. Don't they show a consistent pattern, a tendency, a specific way of behaving that makes it much more likely he committed the crime we're considering right now?
Yeah, it's a powerful argument, known legally as tendency evidence. And it makes intuitive sense on one level. I mean, doesn't a pattern of behavior tell you something? But in the courtroom where the stakes are incredibly high, using that kind of evidence creates a complex legal minefield. The crucial question becomes, how convinced do you, the juror, have to be that those other alleged acts actually happened before you can use them as building blocks to infer that tendency?
And does it matter if those other acts are themselves formal criminal charges the jury also has to decide?
Exactly. And how is the judge, your guide through the trial, supposed to explain all of this to you without confusing you or accidentally lowering the fundamental standard of proof required for conviction?
This isn't just a theoretical puzzle, is it? It sounds like a question that goes right to the heart of fairness in criminal justice.
It absolutely does. And it's a question that caused such fundamental disagreement between judges in Australia that it ended up being battled out at the absolute highest court in the country.
And that's the case we're diving deep into today.
That's right. The Director of Public Prosecutions v. Benjamin Roeder, a pseudonym. This deep dive isn't about reading a textbook definition. It's really a dramatic story of legal principles clashing, a precise step-by-step journey through the Australian court system, and ultimately a landmark clarification on how judges must direct juries in certain complex criminal trials.
So our mission today is to guide you through this fascinating legal saga. We'll take these complex concepts, tendency evidence, standards of proof, jury directions, and, unpack them clearly. We'll introduce you to the key players, the legal teams who fought this battle at each level, follow the case's compelling procedural climb from a pre-trial hearing all the way to the high court.
Yeah, understand the arguments that convinced and maybe those that didn't.
And explain exactly what this final judgment means for how justice is delivered in Australia.
And our understanding for this deep dive is built on a pretty solid foundation. We've got a comprehensive stack of documents provided by you, our listener. We have the court judgments from the County Court, the Victorian Court of Appeal, and the High Court.
Right.
Plus the detailed written submissions filed by both the Director of Public Prosecutions and Benjamin Roeder's defense team in the High Court, critical chronologies outlining the timeline, and other relevant materials. So these sources give us a really privileged look into the strategic arguments and the judicial reasoning at every turn.
All right, let's set the stage for this legal drama then. Every case has its key characters, and even with pseudonyms, we can understand their crucial roles and, I suppose, the stakes involved.
Yeah, absolutely. At the very center of this case is the individual known as Benjamin Roeder. And the use of a pseudonym is standard, necessary practice in proceedings of this nature, particularly those involving allegations of sexual offenses against children.
That makes sense.
It serves a vital purpose in protecting the privacy and identities of the complainants, but it also helps prevent potential prejudice to the accused, especially given the sensitive nature of the allegations and the possibility of future proceedings.
Yeah.
In the High Court appeal, Benjamin Roeder holds the position of the respondent. He is the party defending the decision made by the court below, the decision the Director of Public Prosecutions is appealing.
So he's one arguing that the lower court got it right on how the jury should be directed. What are the allegations against him specifically?
The allegations are, as mentioned, very serious. Benjamin Roeder was facing 27 charges of sexual offenses. These charges related to 2 children of his former domestic partner, identified by the pseudonyms M.W. and E.W.
Right.
The period over which these alleged offenses occurred is quite substantial, spanning from 1999 through to 2011. And this long time frame is significant because, it can make evidence gathering and recall challenging for all parties involved.
I can imagine. And the complainants, M.W. and E.W., they play a critical role not just as the alleged victims, but specifically in relation to this legal issue of tendency evidence.
Absolutely. The prosecution's case relies heavily on the evidence provided by M.W. and E.W. Their testimony forms the factual basis of the 27 charges, and crucially, it's this evidence that the prosecution seeks to use alongside other material to establish the alleged tendency of the accused.
Okay.
Now, in the earlier stages of the proceedings, there was also a third complainant referred to as CW.
And what happened with the charges involving CW? Did they proceed?
Well, the charges relating to CW were ultimately severed from the indictment that was before the court, at the point this specific legal dispute arose and went on appeal.
Severed. What does that mean in practice?
Severance is basically a procedural decision made by the court, often to manage complex trials. It might be done to simplify the issues for the jury, maybe group similar charges together, or sometimes to address potential issues of prejudice that might arise from hearing vastly different sets of allegations in a single trial. So in this case, the severance meant the legal arguments about the jury direction concerning tendency evidence focused squarely on the allegations involving MW and EW and the evidence related to those 27 charges, plus some other non-charged acts we'll get into.
Right. That clarifies the people involved and the core allegations that led to this specific legal fight. Now, let's talk about the legal heavyweights, the lawyers navigating this complex issue through the courts. On one side, representing the state's interest, the Director of Public Prosecutions, the DPP,
The prosecution.
and on the other, Benjamin Rutter's defense team, fighting for his rights and arguing for particular trial safeguards.
Yeah, and as this case ascended the judicial ladder, the legal teams evolved, bringing increasingly senior counsel to bear on these complex points of law. At the Victorian Court of Appeal stage, and initially before the High Court, the DPP was represented by Mrs. S.C. Clancy.
Okay.
But when the case reached the High Court for the substantive appeal hearing, it was led by the Solicitor General for Victoria, Mrs. R.J. Orr Casey. She appeared alongside Mrs. Clancy and Mr. M.Q.T. Nguyen.
The Solicitor General, that's significant, isn't it?
Oh, absolutely. The Solicitor General's direct involvement signals just how important this issue was viewed by the state government. It required the attention of their most senior legal representative to argue the point before the highest court. The instructing solicitors for the DPP throughout were the Office of Public Prosecutions.
Wow, that really underscores the significance of the legal question at stake.
Yeah.
It wasn't just routine. The state brought in their top legal officer. And for Benjamin Ruther, who was arguing his case.
For Benjamin Ruther, his defense in the High Court was led by Mr. T. Casamattis KC, appearing with Mr. C.K. Wareham. Now, Mr. Wareham had also represented Mr. Ruther at the Victorian Court of Appeal and was likely involved at the county court trial stage as well.
Okay.
Their instructing solicitors were Dribbin and Brown criminal lawyers. And bringing in King's counsel at the High Court level, especially a leading Casey like Mr. Casamattis, well, it demonstrates the robustness of the defense being mounted and their commitment to arguing for the specific jury direction they believed was necessary for a fair trial.
So we see a real battle of highly experienced legal minds, top barristers, arguing these fundamental points of trial procedure. And their arguments were presented before a series of judges as the case progressed up the hierarchy.
Precisely. The initial ruling that sparked this entire appellate journey was made by Judge McInerney in the County Court of Victoria. His pre-trial decision on the jury direction was the first judicial word on this specific issue in this case.
Right.
When the DPP appealed, the matter went before the Victorian Court of Appeal, specifically Justices Priest, Nile, and Taylor. Their collective decision then led to the final assent to the High Court of Australia.
And the full bench heard it there.
Yes, the full bench of 7 justices heard and decided the appeal. Chief Justice Gagler and Justices Gordon, Edelman, Stewart, Gleeson, Jaggett, and Beach-Jones. Seeing the case reviewed by judges at every level, culminating in the full High Court bench, really emphasizes the profound legal importance of the question they were asked to resolve.
Okay, we've met the players. Now let's follow the path this case took, that dramatic procedural climb through the courts that led to this High Court showdown. It started, as you said, even before the trial properly began.
That's right. The initial charges regarding MW and EW were filed back in January 2020, with the charges concerning CW following in July 2021. But the procedural step that really set the stage for this specific legal dispute was the prosecution's decision to serve what's called a tendency notice.
A tendency notice. What exactly does serving that signal? What does it do?
Well, it's the formal legal mechanism by which the prosecution informs the defense and the court that they intend to lead evidence and argue that the accused has a particular tendency.
Okay.
This tendency is like a characteristic, a pattern of behavior, or maybe a state of mind that is relevant to the alleged offending. The argument is that proof of this tendency makes it more likely that the accused committed the specific offense they are charged with.
Right. So in a case like this, what kind of tendency might they allege?
It could relate to things like having an improper sexual interest in children, or perhaps exploiting a position of trust, for example. Things that establish a pattern relevant to the charges.
So the prosecution is essentially saying, we're going to show he has this specific tendency, and that helps prove he committed the crimes he's charged with. What evidence did they rely on in the tendency notice in this particular case?
Now, this is a really crucial point. The tendency notice relied on all of the evidence relating to the 27 sexual acts that formed the basis of the charges against Benjamin Roeder involving MW and EW. So the charged acts themselves.
Right.
Plus, it also included evidence of 6 other instances of sexual misconduct that were not the subject of any charged offenses in this indictment.
Ah, okay, so uncharged acts as well.
Exactly. The prosecution intended to argue that the evidence of these 27 charged acts, combined with the evidence of the 6 uncharged acts, collectively demonstrated the alleged tendency.
Okay, so they wanted to use both the charged acts and the uncharged acts to build this picture of a tendency. And this is where the first battle began, in the county court, before Judge McInerney.
Precisely. The stage was a pre-trial hearing before Judge McInerney in September 2023. And here's where it gets particularly interesting. The defense didn't actually challenge the admissibility of this tendency evidence.
Really? They didn't try to keep it out?
No. They conceded that both the uncharged acts and the charged acts could be admitted and used by the jury as tendency evidence. The fight, the whole dispute, was focused solely on the jury direction, specifically how the judge should instruct the jury about the standard of proof required for the charged acts when those acts were being considered for the purpose of proving the tendency.
Wait, hang on. So the defense agreed the jury could hear about these other charged acts as part of the tendency argument, but they wanted a specific instruction about how sure the jury had to be that those charged acts happened before they could use them for tendency.
Exactly that. And their argument was heavily based on an earlier Victorian Court of Appeal case called Dempsey. They argued, relying on Dempsey, that before the jury could use evidence of a charged act as a piece of evidence contributing to the alleged tendency, they must first be satisfied beyond reasonable doubt that that particular charged act actually occurred.
Beyond reasonable doubt, the same standard needed to prove guilt on that specific charge itself.
Exactly.
That seems almost circular, doesn't it? Proving the act BRD just to use it as evidence to help prove the act BRD.
Well, that's the core tension right there.
Yeah.
The prosecution vehemently opposed this. They argued it was directly prohibited by Section 61 of the Jury Directions Act 2015, Vic.
Section 61, what does that say?
They argued Section 61 lists the only matters a judge must direct a jury must be proved beyond reasonable doubt, basically. The essential legal elements of the offense or the absence of any relevant defense. Using an act as evidence to support an alleged tendency, the prosecution contended, is not the same as proving an element for the purpose of conviction on that charge. Therefore, Section 61 prevented the judge from giving the direction the defense wanted. They also argued that the earlier Dempsey case was either wrongly decided or could be distinguished from this situation.
So the prosecution's point was essentially, the law is clear. Prove the elements BRD and only the elements. Don't invent new things the jury has to prove BRD along the way just because it feels fairer.
That's a good way to put their stance, and Judge McInerney, hearing these arguments, ultimately sided with the defense on this critical point.
He did. Why?
His Honor was deeply concerned about the practical reality for the jury. He felt that asking a jury to apply 2 different standards of proof to the same factual allegation, a potentially lower standard for its use in tendency reasoning, and then the beyond reasonable doubt standard for deciding guilt on that specific charge would be intellectually challenging, maybe even impossible for the jury. He worried it would ultimately undermine the fundamental criminal standard of proof.
How did he put it?
He described it in a phrase that really resonated through the later appeals as an act of sophistry.
Wow, an act of sophistry. That's strong language.
It is. It really captures the judge's struggle with making this legally sound and practically understandable for a jury. He concluded that finding a charged act occurred necessarily involved finding elements of the charge, and thus Section 61 of the JDA must apply, requiring BRD proof even for the tendency purpose.
Okay, so he buys the defense argument and thinks it's necessary for fairness. How did he then propose the jury navigate this if they have to prove each charged act BRD before using it for tendency?
Well, to manage this, Judge McInerney proposed a very specific and quite complex sequential direction.
Sequential, how will that work?
He planned to tell the jury to first consider the 6 uncharged acts those could be used for tendency reasoning without a specific BRD standard attached to proving those acts. Then they would consider charge 1. For charge 1, they could use the uncharged acts for tendency plus the evidence relating to charge 1 itself, but only if they first found charge 1 proved beyond reasonable doubt.
Okay.
Then they'd move to charge 2. For that, they could use the uncharged acts plus evidence from charge 1, but only if charge 1 was proved BRD, plus evidence from charge 2 only if charge 2 is proved BRD, and so on, working their way sequentially through all 27 charges.
Oh my goodness. Okay, that sounds incredibly complex to keep track of as a juror. It's like asking them to build the tendency picture 27 different times, and each time potentially using a different subset that are charged acts, depending on which charge they've already decided, meets the BRD standard.
It certainly presented a significant cognitive challenge, yes. And recognizing that his ruling involved a novel and important point of law, Judge McInerney granted the prosecution's application to certify the question for appeal before the trial even commenced.
So he basically said, this is a big deal. Let's get the higher courts to rule on this specific point before we potentially run a whole trial based on a direction that might be wrong.
Exactly. It immediately elevated the dispute, bypassing the usual trial then appeal route for this specific pretrial ruling on the direction.
Which led straight to the Victorian Court of Appeal. What happened there? Did they agree with Judge McInerney?
The Director of Public Prosecutions applied for leave to appeal Judge McInerney's interlocutory ruling. The appeal was heard by a panel of 3 justices of appeal: Priest, Neal, and Taylor. They considered the arguments from both sides in October 2023.
And how did they see the issue? Did they think the sequential direction was workable?
Well, the Court of Appeal acknowledged the High Court's earlier decision in R.V. Bauer. That case generally discouraged judges from directing juries to find uncharged acts proved BRD for tendency purposes.
Right. We'll probably come back to Bauer.
We will, but the VSCA distinguished Bauer, viewing it as limited perhaps to cases with a single complainant and only uncharged acts. Crucially, the Court of Appeal agreed with Judge McInerney's fundamental concern. They were worried about the risks of circular reasoning and potentially undermining the BRD standard if a charged act could be used for tendency without first being proved BRD.
So they shared his concerns about the sophistry.
Essentially, yes. They concluded that directing the jury without that BRD requirement for charged acts used in tendency would invite impermissible circular reasoning and risk the jury applying a less rigorous standard of proof than required for conviction.
And so they validated the trial judge's core concerns about the potential for jury confusion and unfairness.
Exactly. And based on those concerns, they interpreted Section 61 of the JDA differently from how the prosecution read it. They concluded that the proposed direction, requiring BRD proof for charged acts used in tendency, was not prohibited by Section 61. They effectively read Section 61 as allowing for such a direction when it was deemed necessary to prevent potential jury confusion and safeguard the BRD standard in this specific context of charged acts also being used as tendency evidence.
So they carved out a sort of exception or a specific application for this scenario.
You could see it that way. And the practical result of that finding.
What was the outcome?
The Victorian Court of Appeal refused the DPP's application for leave to appeal.
They refused leave. So Judge McInerney's ruling stood.
It did. At this point, if the trial were to go ahead, the judge would have been required to give that complex sequential direction requiring BRD proof for charged acts before they could be used for tendency.
So the DPP had now lost at 2 levels of court: the trial judge and the Court of Appeal. But clearly they didn't stop there. This issue was obviously important enough to push it all the way to the highest court in the land.
Absolutely. The Director of Public Prosecutions decided to seek special leave to appeal to the High Court of Australia. And special leave, as you know, is required because the High Court doesn't hear every appeal. It selects cases of significant legal importance, often to resolve conflicting interpretations of the law between states or address novel issues or correct perceived serious errors by lower courts.
So it's a high bar to get your case heard there.
It is. The application for special leave was filed in November 2023 and heard by a single High Court justice, Justice Gordon, in December 2023.
And the same senior legal teams were present for that hearing, the Solicitor General versus Mr. Casamidas KC.
Yes, the Solicitor General, Mrs. Orr KC, along with Ms. Clancy and Mr. Nguyen, represented the DPP, arguing why the High Court should hear this case, why it met the special leave criteria. Mr. Casamatis Casey and Mr. Wareham argued against granting special leave, contending that the Victorian Court of Appeal's decision was correct, or at least raised no issue of sufficient national importance to warrant the High Court's attention.
And Justice Gordon's decision.
Justice Gordon, after hearing the arguments, granted special leave.
So the High Court agreed it was important enough.
Yes. That was the crucial signal that the High Court indeed saw the critical legal question raised by the split in the lower courts and felt it required resolution at the very apex of the Australian judicial system.
Which then led to the final determinative stage. The hearing before the full bench of 7 justices of the High Court in March 2024.
This was it. This was where the fundamental legal interpretations were laid bare and rigorously tested. Both the DPP and Benjamin Rotter's defense team presented their most comprehensive arguments, supported by detailed written submissions, each urging the High Court to accept their view on how the Jury Directions Act should be interpreted and applied in this complex situation.
All right, let's dive into those arguments then. What was the core case the Director of Public Prosecutions presented to the High Court? What was their strongest pitch?
The DPP's case, led by the Solicitor General, Mrs. O'Casey, was primarily anchored in a strict interpretation of the Jury Directions Act 2015. Their lead argument, the absolute core of their position, was that Section 61 of the JDA means precisely what it says.
Which was?
That the only matters, and they really stress that phrase, the only matters a judge is required to direct a jury must be proved beyond reasonable doubt are the elements of the offense charged or the absence of any relevant defense. Nothing else. Full stop.
The only matters. That phrase does seem pretty definitive, doesn't it?
That was exactly their point. They argue that using an act as a piece of evidence to support an alleged tendency is fundamentally different from proving an element of the offense for the purpose of securing a conviction on that specific charge.
Okay.
They contended that the Victorian Court of Appeal had made a critical error by essentially conflating these two distinct concepts, the ultimate legal elements of a crime, and the evidence presented to prove those elements, or in this case, to prove an intermediate fact like a tendency.
So the DPP was saying, look, you're mixing apples and oranges here. An act used as evidence for tendency isn't in the same legal category as an act being proved as an element of the crime charged.
Exactly that. And they buttressed this textual argument by referring to Section 62 of the JDA. Now, this section explicitly abolished various common law rules that previously required judges to give BRD directions on matters other than elements and defenses.
Okay, what kind of rules did it abolish?
Crucially, it abolished the rule from the famous case of Shepard, which mandated BRD proof for indispensable intermediate facts, basically. Facts that were essential links in the chain of reasoning towards guilt.
Right. The Shepard rule, an intermediate fact that's absolutely necessary for the conclusion, had to be proved BRD itself.
Yes, that was the old common law position. The DPP argued that tendency evidence, while powerful, is often a form of circumstantial reasoning involving intermediate facts. By deliberately abolishing the Shepard rule, the JDA demonstrated a clear legislative intent to remove the requirement for BRD directions on these intermediate steps or the evidence that supports them.
Okay.
The focus of the BRD standard, they argued, was meant to be solely on the ultimate elements of the offense. The direction proposed by the defense and endorsed by the lower courts requiring BRD for charged acts used in tendency effectively tried to reintroduce a Shepard-like requirement that the act had specifically abolished.
So it went against the grain of the legislation.
Exactly. They argued it went directly against the legislative purpose, which included simplifying and clarifying jury directions, not complicating them by adding new, judicially created proof standards for evidentiary steps along the way.
Okay, so the JDA's text is clear. Its legislative history, particularly abolishing the Shepard rule, reinforces that clarity. What else did the DPP argue? Did they mention that Bauer case again?
Oh, absolutely. They argued strongly for consistency with the High Court's own prior decision in R.V. Bauer. Remember, in Bauer, the court had held that when uncharged acts are used as tendency evidence, juries should not generally be directed, that those uncharged acts must be proved beyond reasonable doubt for the tendency purpose.
Right.
The BPP submitted that there was no logical or principled basis for treating charged acts differently from uncharged acts when they are being used for precisely the same purpose, namely, as evidence to establish an alleged tendency.
That makes a lot of sense, actually. If the goal is simply to show a pattern of behavior, why should the legal standard applied to a piece of evidence in that pattern depend simply on whether the prosecution chose to lay a charge for that specific act? The act's relevance to the pattern isn't determined by its charging status, is it?
That was precisely their argument. They referenced an observation made by a judge in the NSW Court of Criminal Appeal case, JSVR, who noted that it would create an odd result if the required jury direction varied, simply based on the prosecution's charging decision, a decision which is irrelevant to the evidence's actual probative value in showing a tendency.
Right.
The DPP also argued that the NSW Court of Criminal Appeal, in cases like JS and another called Rassi, had correctly applied the Bauer principle to charged acts, and that the Victorian Court of Appeal had, in their view, misunderstood the basis for those NSW decisions.
So the DPP was essentially saying, look, High Court, our interpretation aligns with the clear text of the JDA, the legislative intent, your own precedent in Bauer, and the approach already taken by the leading appellate court in the most populous state, NSW.
That was certainly a powerful combination of arguments. They also didn't shy away from directly confronting the lower court's main concerns, that fear of circular reasoning and the risk of erosion of the standard of proof.
How do they tackle the circular reasoning point?
The DPP argued, drawing again on those NSWCCA cases like Rassi, that using charged acts for tendency is not circular reasoning. They explained it as the jury considering the same evidence at different stages of its deliberations with a different onus of proof and for a different purpose.
Different stages, different purpose. Explain that again.
They argued the jury isn't assuming guilt on the charged act to then use it to prove itself. Instead, they are sort of provisionally considering the evidence of the act to see if it contributes to establishing an intermediate fact, the alleged tendency. Then, if they are satisfied of the tendency, they use that intermediate fact, the tendency, as one piece of circumstantial evidence to help prove the ultimate elements of the specific offense beyond reasonable doubt.
Okay, so the High Court needed to decide if looking at the same evidence for two different purposes at different points in the deliberation process truly avoids that logical loop, that circularity.
Exactly. That was a key point of contention. As for the erosion risk, the fear the jury might apply the wrong standard, the DPP's argument was that this potential risk, while real, is adequately managed by the other careful directions the judge must give under the JDA framework.
What are the directions?
They highlighted Section 27 of the JDA, which specifically deals with directions on other misconduct evidence, including tendency evidence. They pointed out that model directions exist that guide judges on how to properly introduce and explain tendency evidence and, crucially, how to strongly stress the ultimate beyond reasonable doubt standard that applies to the elements of the offense at the very end of the jury's deliberation.
So they were saying, trust the system, trust the other directions.
Yes, and trust the jury. The DPP argued that juries are presumed in law to follow these instructions carefully. These specific directions on tendency, combined with strong general directions on the BRD standard, are sufficient safeguards, they argued, without needing to add a prohibited BRD requirement to the evidence used for tendency itself.
So the state's argument, in a nutshell, was trust the JDA's framework. It puts the BRD requirement where it belongs on the ultimate elements and provides judges with other tools to manage potential confusion without needing to add a new, complex, and legally incorrect standard for intermediate evidence.
That captures the essence of the prosecution's case very well.
Okay. Now, what about Benjamin Roeder's defense? They were arguing to uphold the lower court's decisions. What was their main line of attack? How did they counter the DPP?
Their primary contention, really the heart of their case, was that the direction requiring BRD proof for charged acts used in tendency evidence was absolutely essential for ensuring a fair trial. They strongly defended the concerns raised by Judge McInerney and the Court of Appeal.
They doubled down on the circularity and erosion risks.
They did. They argued that the risk of circular reasoning was very real and deeply problematic. They weren't convinced by the different stages, different purpose explanation, especially when dealing with the same factual allegation, the charged act. They felt that using an alleged act, potentially assessed at a lower standard for tendency, to then help prove that very same act beyond reasonable doubt for conviction was inherently flawed, a kind of improper bootstrap logic. They saw it as moving from a provisional consideration to potentially contaminating the final assessment of guilt.
So they maintained that the potential for injustice from that perceived circularity was significant and required this specific safeguard, the BRD direction for tendency use.
Exactly. And they were equally, if not more, concerned about the erosion of the standard of proof. They argued that the risk of the jury applying a lower standard, the one used perhaps implicitly to assess the charged act for tendency bleeding into or contaminating their final beyond reasonable doubt assessment for conviction on that specific charge, was acute and real. They felt general directions simply weren't enough to prevent this specific high-stakes risk.
So they needed something more targeted.
Yes. They described the direction they sought as a prudential necessity.
Prudential necessity, what does that imply?
It implies it's needed not just because the statute strictly mandates it, but out of practical wisdom, caution, and a fundamental concern for fairness in the real world of jury deliberations, even if it seemed to cut across the JDA's simplification goals.
Right, it's about practical fairness over maybe a rigid statutory interpretation. How did they deal with the DPP's core argument about Section 61, though? That only matters. Language seems quite restrictive.
They argued that the direction was compatible with Section 61, contrary to the DPP's submission. They supported the lower court's view. Their contention was that a charged act, by its very nature, is inextricably linked to the elements of that charge. It constitutes the factual basis for those elements.
Okay.
Therefore, requiring BRD proof for it, even when it's being considered for tendency, is actually consistent with Section 61's requirement that elements be proved BRD. They argued the JDA's aim to simplify directions shouldn't be pursued at the cost of overriding such an essential safeguard for fairness.
So they tried to interpret elements in Section 61 more broadly, arguing that the specific conduct alleged is effectively part of the element and thus falls under Section 61's ambit for BRD proof, regardless of the specific purpose for which the evidence is being used at that moment.
That seems to be the approach they took to try and square their desired direction with the text of Section 61. They also, naturally, sought to distinguish the R.V. Bauer case.
How did they argue Bauer didn't apply here?
They argued that Bauer, which dealt with uncharged acts, didn't apply with the same force to charged acts. Charged acts, they contended, are fundamentally different because there are also counts on the indictment that the jury must decide upon BRD anyway for conviction purposes. This intrinsic difference, they argued, creates unique risks of confusion and circularity that weren't present in Bauer, and therefore justify a different approach requiring BRD proof, even for the tendency purpose when it comes to charged acts.
That's an interesting distinction. They're saying the mere fact of it being a formal charge changes how the evidence should be treated by the jury, even when it's being used for a different evidentiary purpose like tendency.
Yes, that was their key distinction from the DPP's reliance on Bauer. And they introduced a rather novel argument, actually, based on principles related to acquittals.
Acquittals. How did that come into it?
They suggested that allowing a charged act to be used for tendency without BRD proof could, in a sense, undermine a hypothetical acquittal on that charge later on. Imagine the jury acquits on charge 1, but they had already used the evidence of charge 1, assessed at some lower standard for tendency, to help convict the accused on charge 2 via the tendency reasoning.
I see the potential issue.
They drew an analogy to principles from cases like Kemp v. the King and Garrett v. the Queen. These cases deal with protecting against using evidence related to prior acquittals from separate, earlier trials to secure a conviction in a new trial.
That seems like quite a leap, though, trying to connect the use of evidence within a single trial to principles preventing the undermining of prior acquittals from entirely different trials.
It was certainly a creative argument, and perhaps highlights how deeply they felt the potential risk of injustice was without the specific direction they were advocating for.
It showed the depth of their concern, for sure. And they were essentially arguing that the framework from that earlier Victorian Court of Appeal case, Dempsey, which supported their position, was correct and necessary for fairness, despite the DPP's challenges.
That's right. They held up Dempsey as representing the correct, fair approach.
Okay. So we had two fundamentally opposed views on how the JDA operates in this specific, complex scenario. The DPP emphasizing the Act's clear text and simplification goals, trusting in other safeguards. The defense emphasizing the practical realities of jury deliberation, arguing for a specific safeguard as a prudential necessity. How did the High Court, all 7 justices, ultimately resolve this crucial disagreement?
Well, the High Court delivered its judgment in April 2024, and the outcome was clear, it was decisive, and notably, it was unanimous. The full bench of 7 justices agreed on the outcome.
Unanimous. After the lower courts were split. That's powerful.
It really is. They granted special leave, confirming the issue's importance, allowed the appeal by the Director of Public Prosecutions, set aside the orders of the Victorian Court of Appeal, and importantly, also set aside the original ruling of Judge McInerney in the county court. The matter was formally sent back or remitted to the county court for further proceedings.
Meaning the trial judge would need to rule on the jury directions again, but this time following the High Court's guidance.
Precisely. And what was the core finding that united all 7 justices? What was the absolute bedrock of their decision?
Yes. What was it?
It was their agreement with the Director of Public Prosecutions on the interpretation of the Jury Directions Act. The High Court held, unequivocally, that Section 61 prohibits a direction that a jury must be satisfied beyond reasonable doubt of charged acts when those acts are being used for the purpose of proving a tendency.
So they adopted the DPP's strict view on Section 61. It means what it says, the only matters, and nothing more.
Precisely. They found that the Victorian Court of Appeal had indeed erred by conflating the elements of the offense with the evidence that supports the proof of such elements. The High Court reiterated that Section 61 exhaustively lists the only matters requiring a mandatory BRD direction, the elements of the charge in the absence of a defense. An act being used as evidence to support an alleged tendency is not, in their view, an element for this purpose.
Right.
Therefore, adding a requirement for BRD proof for that evidence for the tendency purpose is simply outside the scope and indeed precluded by the restrictive wording, the only matters, of Section 61.
And they also relied on Section 62, the abolition of the Shepherd Rule.
Absolutely. They reinforced their interpretation by pointing to Section 62's abolition of common law rules, including Shepherd. The High Court saw this as clear legislative intent to remove the necessity for BRD directions on intermediate matters or the evidence supporting them. Since tendency is considered an intermediate fact, the abolition of Shepherd confirms that the evidence used to prove it, including charged acts, does not attract a mandatory BRD standard for that specific purpose under the JDA framework. They really emphasize the deliberate nature of Sections 61 and 62 in narrowing the scope of mandatory BRD directions.
Okay, so the text and the legislative intent of the JDA were paramount in their reasoning. How did they then address those significant concerns raised by the lower courts about circular reasoning? That seemed to be a major sticking point.
The High Court definitively dismissed that concern. They accepted and explicitly endorsed the approach taken by the NSW Court of Criminal Appeal in those cases like JSVR and RASI. They held that using charged acts as evidence contributing to a tendency is not circular reasoning.
And their explanation was similar to the DPP's argument about different stages and different purposes.
Exactly. The High Court explained that the tendency itself is an intermediate fact. When a jury considers the same evidence, like a charged act, first for tendency and later for proving the charge itself, they are undertaking each consideration at different stages of its deliberations with a different onus of proof and for a different purpose. They stress that there's no improper assumption of guilt required to consider the evidence for its potential contribution to showing a tendency.
So, in the High Court's view, it's a matter of distinct intellectual steps with different objectives, not flawed circular logic. What about the other major concern, the risk of erosion of the standard of proof? Did they just dismiss that too?
Not entirely dismissed, no. The High Court acknowledged that this was a legitimate concern that needed to be managed carefully to ensure a fair trial. However, they fundamentally disagreed with the lower courts on the method of management. They stated firmly that the risk of the jury applying a lower standard inappropriately should be addressed through the careful formulation of directions, not by adding a BRD standard to the tendency evidence itself, which, as they'd found, Section 61 prohibits.
Okay, but how does a careful formulation of directions actually fix that potential problem in the jury room?
They reference Section 27 of the JDA, which provides for directions on other misconduct evidence, including tendency evidence. They also implicitly reference the model directions available to judges. These model directions guide judges to clearly identify all the evidence supporting the tendency, both charged and uncharged acts, direct the jury to consider whether they are satisfied of the alleged tendency significantly without imposing a BRD standard on this finding, and then, crucially, advise the jury that if they're satisfied the tendency exists, they can use it as circumstantial evidence when considering the likelihood of the accused committing the specific charged offenses.
Right.
But critically, the High Court emphasized that these specific directions must be given alongside clear and strong general directions that continually stress the ultimate beyond reasonable doubt standard that applies to the elements of each offense at the final stage of the jury's deliberation.
And they relied on the idea that juries follow instructions.
Yes. The High Court reaffirmed the fundamental legal principle that juries are presumed to understand and follow judicial instructions. They put their faith in that presumption, coupled with carefully crafted directions.
Okay, so the safeguard isn't in making the jury prove each piece of tendency evidence BRD along the way, but in guiding them very clearly on how tendency evidence fits into the overall picture, and repeatedly emphasizing that the final decision on guilt for each charge requires BRD proof of all the elements.
That is the High Court's clear position, absolutely consistent with the framework of the JDA as they interpreted it. They also explicitly settled the debate regarding Bauer.
What did they say about Bauer applying to charged acts?
The High Court confirmed that the principle established in Bauer, which held that uncharged acts used for tendency don't require a BRD direction for that purpose, does apply equally to charged acts used for tendency. They found no principled justification for treating them differently when used for the purpose of establishing the alleged tendency. They agreed with that observation from the NSW case JSVR that requiring a different standard based simply on charging decisions would indeed create an odd result.
So they directly addressed the DPP's argument on that point and sided with it. What about that novel argument the defense raised, based on the acquittal principles from Kemp and Garrett? Did the High Court engage with that?
They did, but they rejected it entirely. They stated very clearly that the principles in Kemp v. the King and Garrett v. the Queen applied to the legal effect of prior acquittals from earlier separate trials. They held that those principles have no application in this case, which concerns deliberations within a single trial.
So that creative analogy didn't land with the High Court at all. And finally, what did they think of the very complex sequential direction that Judge McInerney had proposed as his practical solution?
The High Court actually found that the sequential direction proposed by the trial judge highlighted the error in the lower court's reasoning.
How so?
They reasoned that if the evidence, including the charged acts, is properly admitted and conceded to be cross-admissible for tendency purposes, meaning it's relevant to proving the tendency across multiple charges, then a sequential direction that prevents the jury from considering all the relevant tendency evidence when assessing the tendency in relation to a specific charge is logically incorrect. It fragments the evidence inappropriately.
Right.
While a judge certainly has the power to direct the jury on the order in which they should consider individual charges for verdict purposes, this cannot override or restrict the jury's ability to use evidence that is properly admitted and relevant to the issue of tendency as it applies holistically across the charges.
So the High Court saw the proposed solution as creating its own problems by artificially compartmentalizing evidence that the law actually intended to be viewed more holistically for the purpose of showing a pattern or tendency.
Indeed, that seems to be their view. By setting aside the lower court orders and remitting the case back to the county court, the High Court provided very clear guidance on the proper approach moving forward.
What would that proper approach look like, based on their judgment?
Based on their reasoning and their favorable references to the NSW-CCA cases, the trial judge, should the case proceed, will be expected to give a single, comprehensive tendency direction. This direction should identify all the evidence relied upon for tendency, both the charged and the uncharged acts. It should direct the jury to consider whether they are satisfied the alleged tendency exists, again, without imposing a BRD requirement for that finding. And then it should instruct them that if they are satisfied of the tendency, they can use it as circumstantial evidence when considering the likelihood of the accused committing the specific charged offenses.
And always with those strong reminders about the final standard.
Absolutely. This must be coupled, as they stressed repeatedly, with careful, strong directions reminding the jury of the absolute beyond reasonable doubt standard required for proving the elements of each offense and the need to consider each charge separately for verdict.
That provides a very clear, unambiguous framework for judges grappling with this situation going forward. So pulling it all together then, what are the main echoes and the lasting impact of this High Court decision in DPP v. Roeder?
Well, one of the most significant impacts is the definitive clarification it provides on how to interpret the Jury Directions Act 2015, particularly Section 61 and 62 in Victoria. It really settles the debate that emerged in this case.
Right.
It confirms the High Court's view that the Act rigidly limits mandatory beyond reasonable doubt directions from the judge to the ultimate issues. The elements of the offense and the absence of defenses, deliberately excluding intermediate facts like tendency or the specific evidence used to prove them.
So it strongly affirms the legislative direction we discussed toward simplifying jury directions by strictly defining what needs that highest standard of proof explained by the judge.
Precisely. And in doing so, it definitively settles the specific question that was at the heart of this case. The standard of proof for charged acts when they are used as evidence to support an alleged tendency. The answer is clear. It is not beyond reasonable doubt for that purpose. This resolves the conflict that arose between the interpretation favored by the County Court and the Victorian Court of Appeal and the one argued for by the Director of Public Prosecutions.
And importantly, it also brings the approach taken in Victoria now in line with the jurisprudence that had already developed in New South Wales, particularly in those cases like JSVR and RASI.
Yes, that harmonization is really important for consistency in how the Uniform Evidence Act framework, which applies in both states and other jurisdictions, is interpreted and applied in this specific, quite tricky context. It means trial judges and practitioners across these key jurisdictions now have a consistent, High Court-endorsed approach to refer to.
And the decision reinforces the High Court's view on how potential risks like jury confusion or misapplication of standards should be handled, doesn't it?
Absolutely. It underscores their position that these risks are best addressed through the existing tailored directions available under the JDA, like those specifically designed for tendency and other misconduct evidence under Section 27, and through robust, clear, general directions emphasizing the ultimate BRD standard for conviction on the elements of each charge. It rejects the idea, favored by the lower courts in this instance, that the solution lies in creating new, complex proof standards for intermediate evidentiary steps.
This case really seems to highlight that fundamental tension we talked about between the legislative goal of simplifying jury instructions, making them maybe more accessible for jurors, and the judiciary's inherent responsibility to ensure practical fairness in the courtroom. The High Court seems to have come down firmly on enforcing the legislative simplification here.
It is a prime example of that very tension. The High Court's decision, by enforcing what they saw as a strict reading of the JDA, places significant reliance on the effectiveness of other directions and fundamentally on the jury's ability to follow them carefully to safeguard against the risks the lower courts were so worried about. It trusts that a clear explanation of how tendency evidence can be used, coupled with strong emphasis on the ultimate BRD standard for the elements, is sufficient.
So for trial judges in Victoria and likely other states operating under similar evidence laws, the guidance is now crystal clear. When charged acts are part of the evidence used for tendency reasoning, there is no requirement, in fact, it's prohibited to direct the jury that they must find those charged acts prove BRD for the purpose of using them for tendency. This should streamline jury directions in this specific challenging area and hopefully prevent the kind of lengthy, multi-level pretrial litigation we saw spiral out of this single direction issue.
It provides a clear rule, yes. It ends the judicial disagreement on this specific point and sets out the path for how these directions should be formulated going forward.
So, just to recap the journey. This case began with a crucial disagreement in a county court pretrial hearing about a single but deeply important point of jury direction concerning the standard of proof for tendency evidence when that evidence includes charged acts. That disagreement wound its way through the Victorian Court of Appeal, which upheld the trial judge's cautious approach and finally landed, via special leave, in the High Court of Australia.
And the High Court, in a unanimous decision, overturned the lower courts.
Right, providing a definitive interpretation of the Jury Directions Act and settling the law on how juries should be directed in these complex circumstances, focusing that mandatory BRD standard tightly on the ultimate elements of the offense.
It's really a powerful demonstration of how even seemingly technical points of trial procedure and statutory interpretation can rise to the highest level of the Australian legal system.
Right.
Why? Because they directly impact the fairness and integrity of criminal trials and the practical guidance given to juries of ordinary citizens tasked with an incredibly difficult job. The way a judge explains the law and the evidence fundamentally shapes the jury's task.
It certainly does. And this deep dive leaves us perhaps with a significant question still hanging in the air. The High Court has strongly endorsed the legislative path towards simplifying jury directions, trusting that the framework of the Jury Directions Act, with its clear limits on mandatory BRD directions and its reliance on other specific and general directions, provides sufficient safeguards. But in these deeply complex cases, often involving sensitive evidence and intricate reasoning processes like tendency, where the potential for misunderstanding feels very real, does simplifying the directions themselves risk oversimplifying or perhaps even increasing the difficulty of the jury's actual task in the deliberation room? Can general directions about the ultimate BRD standard truly prevent the risks of confusion and potential unfairness that the lower courts were so demonstrably concerned about? How does that legal presumption that juries follow instructions stack up against the practical challenges of human reasoning when faced with such nuanced distinctions?
That's a question that remains central, I think, to the ongoing challenge of ensuring justice is not just legally sound in theory, but genuinely delivered in practice, a vital question for the future of jury trials.
Indeed. Well, thanks for joining us for this deep dive into the Director of Public Prosecutions v. Benjamin Roeder, a pseudonym.
Always a pleasure.